you sign with a traditional publisher, they give you an advance, and then at some point they decide to terminate production of your book, do you have to give your advance back? Today, we're talking to everybody's favorite IP and entertainment lawyer, Tony, to find out more, as this has been popping up on social media more and more recently, and you need to understand what your contract actually says in terms of who is violating that contract, if there's a violation of that contract, and what to do with the money that you've already been paid. Let's jump in.
My name is Tony Oyakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
An interesting conversation popped up on social media this week, Tony, all about when an author is signing their manuscript to a traditional publisher and they get through part of the publishing process but do not actually put the book out into the world. Do those authors then get to keep the advances because they have not gone through the process of putting that book out into the world? It kind of sounds like breach of contract on the publisher's part. So what do you have to say about that?
Yeah, absolutely. So, I think we should regard publishing agreements kind of like a mother agreement with little promises that are laid out. So when you're talking about advances, typically a publisher will give you $10,000, $20,000, $30, whatever the negotiated price is for the advance upon delivery of the final draft or a version of the draft of the manuscript of whatever book you're working on. Maybe this is the kind of thing that's laid out throughout the course of the agreement. So if you fulfilled your end of the promise, if you're an author and you fulfilled your end of the promise of delivering a draft, surely, I think you're right to say that, you don't have to give back that advance, because at the end of the day, you delivered on that promise and they were supposed to deliver in return. Now, what this does sound like, though, from a general point of view, is a breach of contract situation. The reason why I think we should at least entertain that thought is because, if, again, part of the overall promise was that this publisher was supposed to publish this book and it didn't happen, instinctually, that just makes the most sense. Now, of course, reviewing the terms of the agreement are going to be quite paramount, namely because there could be certain provisions that relate to why the publisher did not choose to publish, but certainly can give the author guidance on what causes of action they can pursue if they decided to take legal action against the publisher. So, for example, one thing that's coming to mind in a situation like this is I would love to know if the publishing agreement has an assignment clause. Assignment clauses usually lay out that if, let's say, something were to happen where the publisher was not able to rightfully perform its duties of publishing the book, it could assign those rights of the manuscript over to another publisher to then carry on that duty. Or, in situations that does happen where, a company files for Chapter 11 bankruptcy, they completely fold, but they get acquired by somebody else. That's where assignment could also take place as well. So I would be curious to know if there was even some type of assignment lingo in that specific publishing agreement. But then sometimes there could be a remedies clause where it lays out like what happens if one party didn't do its part, or what legal action can take place. Now, I'm not entirely sure if this is like an industry standard, but I will say that in some aspect of the entertainment industry, for whatever reason, everybody loves an arbitration. I don't like arbitrations only because I feel that sometimes an arbiter or even a mediator, they call it mediations as well, but those types of proceedings, they typically are less formal than an actual court. And I think sometimes there's a little bit more wiggle room for the offender to actually get their way in those types of situations. I think that a court of law truly does provide the best opportunity to have an unbiased review of the law. Again, to the extent that you hope that there is an unbiased review of the law, sometimes there could be a judge that could view contract law through one lens, through one type of perspective or another perspective. But if it's a jury trial, of course, that's where you have a jury of your peers reviewing that type of situation. All that to say, that type of lingo could be found in a publishing agreement. It could let you know if the publisher didn't do their part, what action can you, the author, take? Do you have to go to arbitration? Do you have to go through a mediation? Or could you contact your lawyer and go through the process of filing a lawsuit? I would advocate, obviously, for the latter, going to the lawyer, of course, to have them review the publishing agreement, because even if there is an arbitration or mediation involved, your lawyer can go on your behalf and handle that type of claim and get an outcome that's rightful for you. So it's a very, very interesting story for sure. And I think that there's a lot to it. It's all going to depend on what the contract language says, but just on its face, it feels very breach of contract ish, if you know what I mean.
So once you have signed on with a publisher, after having your lawyer read over the contract so you understand your rights and what you're going to do in these situations, then you have the ability to go back and read that contract and make sure you understand what it is that you're doing to take those next steps, whether it was a breach of contract, whether you are giving back an advance, whether you are able to keep that advance. All these things are going to be spelled out up front. And with the help of your lawyer, you will make sure you are legally protected and negotiate the contract to make sure it's fair to you as well. If you have questions on your book advances, on your book contracts, on negotiating with your publishers, go ahead and drop those down below. Tony's going to be back for upcoming episodes, and we're going to make sure we are keeping you legally protected in the publishing space. And as always, you can reach out to Tony on his social medias as well to learn even more about IP and entertainment law. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor.
Drop your questions down below. We are dropping videos daily to help you level up in the publishing industry. So if you have questions on the legal side of things, the writing side, the publishing side, the marketing side, which is my favorite side, now is the time to let us know what you need help with so we can help you to be more profitable this year inside of your author business. We'll see you in the next episode.